So we had these new documents drop on the Idaho 4 case tonight, and I have read them all. They are a notice of filing declaration of Gabriela Vargas in support of the defendant's third motion to compel. That's related to the IGG information. And then we have a 71-page objection to defendant's motion to dismiss indictments on grounds of error in grand jury instructions. All right. I'm going to start with the 5-page because it's shorter. Okay, so this is another expert on behalf of Brian Kohberger. And I'm going to go down to the first page. I'm just going to very briefly sum these up. She is an expert. She just got the case. That we're still in August, and she said she's been engaged as an expert in this matter since August of 2023. So max a couple weeks. So her educational background is in administration of justice and criminology. She has spent her professional career working for the California court systems, law firms, insurance, and finance firms. And she said, I got my start in this field after receiving unexpected DNA results in the spring of 2018. She doesn't really elaborate on that, but I'm wondering if she's speaking of something in her personal life that sparked her passion for this field. That happens a lot in people's lives. Okay, so she says, I'm an investigative genetic genealogist specializing in Hispanic and African American ancestry, degraded DNA, and endogamy. She founded DNA ID and has run the business since 2020. She spent several years doing IGG work for other companies, such as the DNA Doe Project and Identifiers International. She goes on to tell a little bit more about herself and her role there. She has taught IGG fundamentals, best research practices and procedures, DNA data analysis, and she trained incoming genealogists. She goes on a little bit more about her experiences. Let's see. She said she has successfully provided law enforcement with over 50 crime-solving investigative leads. She works with law enforcement nationwide, working on IGG, or investigative genetic genealogy. She says it has revolutionized cold case investigations. And let's see here. All right, so now she gets into kind of the nitty-gritty of what she does and why she's been hired on this case. Okay, so she says the sole focus of the traditional law enforcement databases like CODIS is to compare crime scene DNA against the genetic profiles for those who are known offenders with prior convictions. Now, that's not entirely true. In a lot of places, if you're even arrested or charged, whether or not you were convicted, your DNA is going to be in CODIS. All right. So let's see, utilizes 20 genetic markers and therefore limits the power of DNA analysis, which can and does lead to cases going cold. Says IGG mixes genetic genealogy with advanced DNA testing with traditional genealogy research in an effort to identify a previously unknown DNA contributor in a family tree. All right, so 11, the DOJ recommends that law enforcement seek out IGG services only after all other investigative methods have been exhausted. It is widely known within my industry that many agencies use this technique as the first and only method. 12. The IGG process starts when law enforcement agencies reach out to genealogists seeking collaboration on a case and then contract with the individual for services. 13. Chain of custody is best maintained when the requesting agency sends the crime scene DNA sample to a private lab that is capable of genotyping or whole genome sequencing. Once the sample arrives at the lab, the genealogist usually takes lead on the case until the person of interest is identified. The lab creates a genetic profile of the unknown DNA contributor, and a raw data file containing hundreds of thousands of genetic markers is generated and sent to the genealogist. Okay, now this is a long paragraph, but I'm going to go ahead and read it because I really want to get to 14. That's, to me, the most important one. Okay, she says this file is then uploaded to the public direct-to-consumer DNA databases, GEDmatch, and Family Tree DNA, where autosomal comparisons are made between the subject and thousands of individuals who have voluntarily contributed their DNA profiles to the databases and opted in to allow law enforcement matching. A list of matches who are biologically related to the subject is displayed with some basic identifying information and the amount of DNA shared between the two individuals. This is pretty much the same stuff that C.C. Moore explained and Leah Larkin as well. All right, so this is the part that is a little more in-depth that goes to her expertise. She says tools within the database allow for further analysis of the DNA data and the ability to predict the most likely relationship between the match and the unknown DNA contributor. In-depth research on family history, structure, the DNA data alignment is conducted, and family trees for each match are built back and then forward in time. That doesn't math in my brain, but I mean, I get it. I don't see how they can find the ancestor before the person down from the ancestor, but somebody can explain that to me. Okay. These trees are analyzed by the genealogist for common ancestors, surnames, locations, and any other significant clues that provide insight into identifying the person of interest. Throughout the process, other tools can be used to further analyze Y-DNA and mtDNA, ethnicity, one-to-one and multiple kit comparisons, triangulation, and chromosome segments. That's all Greek to me. Let's just go on to 14. Okay. These database tools have known loopholes that allow genealogists to see matches that have been explicitly declined to participate in law enforcement matching. This is not a glitch in the programming caused by an accident. It is a standard feature within the tools that essentially tricks the system into displaying all matches as opposed to those who have consented to law enforcement matching. This is not a loophole, nor it is something you will stumble upon. Using the tool this way requires effort and knowledge. Great way of explaining that. Basically, she's saying that there's a right way to use the tools, and there's kind of an exploitive way to branch out without permission of certain people who are in other databases other than the two that are allowed, which are GEDmatch and Family Tree DNA. They're saying that if you know what you're doing and you're doing it right, you can weed out everybody except those two databases. But if you do it wrong, you can include family trees and DNA profiles from some of the other ones like Ancestry, 23andMe, and so forth. That's pretty much what she's saying there. But she says that if you're using the tool that way and you are polling matches that have explicitly declined to participate. It requires effort and knowledge and like intent. They're meaning to do that. It's not an accident. 15. Databases for law enforcement cases require a fee to be paid in order to upload the genetic profile. This is not the same for consumers who are not charged. So there, when she says databases for law enforcement cases, she's referring to GEDmatch or Family Tree DNA. You can take your own DNA profile, upload it to one of those databases at no cost. But if law enforcement wants to go in there and access anything or upload a genetic profile to do a search, they're supposed to pay a fee. Many in the field have been known to upload to these sites as a regular consumer to avoid paying the associated fees and to bypass having opted out matches. In addition, some databases restrict law enforcement uploading cases. However, that has not prevented it from happening. So that's pretty self-explanatory. She's known that law enforcement has done that in the past. That is a possibility. In this case, she's not saying that it has happened in this case, but she's saying that it might have. And I'll explain why in just a second. And the lastly, number 16, which I am seeing misrepresented or whatever all over the place tonight. She says, I am aware that law enforcement has obtained results in ways prohibited by the terms of use and prohibited by their own policies. That was the last one. Now, just to explain 16, she's not talking about this case. She doesn't know if law enforcement obtained results in ways prohibited, but she is saying that she's aware that it has happened, and that's her statement. The reason that all of this is important is it could have happened in this case. It may not have, but it could have. That is why the defense is asking for this motion to compel so they can check and see if that happened. I believe that when the judge reads this document, which I have to say is very well thought out, very concise, very easy to understand, very easy to see their point in this document, this one might be the winner. They just might get their motion to compel. The state just might lose their motion for protective order. They tie together. So for this one, I would call this one a win for the defense. Honestly, this sounds like a really smart lady who knows how to explain possible irregularities and possible problems with IgG. And I do want to add, if the things that I listed happened on this case, that could be the reason why the state doesn't want to hand over the IgG. They might have taken some shortcuts to get to information, but they might not have. They want to treat the IgG information as merely a tip so that they don't have to hand it over to the defense. I say hand it over. I personally think just hand it over. Make sure everything's on the up and up. This is a death penalty case. I don't think things like that should be glossed over, but that's just my opinion. All right, moving on to the next document. This is 71 pages long. However, the first 12 or 13 pages are the important ones here. And the rest of the pages are mailing documents, service, and exhibits that support this objection. So those exhibits are important to the state, but they're not really important for us to read. I'll just show you one or two of them at the end here. All right, so this is the state's objection to defendant's motion to dismiss indictment on grounds of error in grand jury instructions. I'm mainly going to read just the main portions of this. All right, so they start by saying the state submits this objection. All right, so it starts with the state submits this objection to address defendant's assertion that the standard of proof in a grand jury proceeding is beyond a reasonable doubt. Far from novel, defendant's argument has made numerous appearances throughout the state in recent years. Even those pushing this jarring theory are forced to concede, quote, the whole of modern jurisprudence on this issue is against it, unquote. And to the state's knowledge, every court in the state that has addressed this argument has soundly rejected it. They cited a few cases there. A, the Idaho Supreme Court has held probable cause is the correct standard of proof for a grand jury. I mean, logic would tell you that a grand jury couldn't possibly find any defendant guilty beyond a reasonable doubt because they're not seeing the defense. It's not just me that thinks that. Okay. So I'm going to scan by through here on a lot of this stuff. They literally called this nonsense. They said defendants claim that the court's numerous probable cause statements in the case of Edmondson were dicta. Nonsense. A statement from the Supreme Court is only dicta if the statement is not necessary to decide the issue presented. All right, so let's keep going here. I don't need to read all of this, but I'll read this portion right here. The purpose of a grand jury proceeding and a preliminary hearing is to determine probable cause. Any advantage that a preliminary hearing affords a defendant is purely incidental to that purpose. The independent grand jury's function would be duplicated by requiring a subsequent preliminary hearing. All right, and then defendant suggests this holding is dicta because the court noted that, quote, Edmondson did not request a preliminary hearing, unquote. And I'm scrolling, we're scrolling. And still scrolling all these cases that they're citing. And a lot of these are at the bottom as well as exhibits. Okay. And again, the purpose of a grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. Obviously, a trial means a trial with a judge and jury. So, the determination of guilt or innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports a finding of probable cause, it is not for an appellate court to set aside the indictment. So they're saying, Judge, you can't and you shouldn't do that anyway. B, Section 19-1107 sets the standard for proof for grand juries at probable cause. So let's see, the statute's plain language. The statute is considered as a whole, and words are given their plain, usual, and ordinary meanings. Just a moment. Keeps going on, more cases and more cases. And then here is the actual plain language of the statute. It reads, quote, the grand jury ought to find an indictment when all the evidence before them, taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury, unquote. Okay. I'm scrolling and scrolling. It just basically explains there that in their judgment means the grand jury. Same, more cases. My favorite part's coming up. This is just more explaining. And I can't believe the state's having to explain this to a death penalty public defender. But here we are. Okay. All right. So the grand jury must determine whether an offense has been committed and whether there is probable cause to believe that the accused committed it. That's ICR 6.5A. Okay, and then they say that because the statute and the rule can be read together to set the standard of proof for grand juries at probable cause, they must be read in that way. Okay, and then they're saying that the defense brought up California statutes and all this stuff. They're arguing back at the defense on a few of the cases that they brought up here, and we're scrolling. All right, and here was an argument that the defense had brought up, stating that statutes in existence at the time of the adoption of Idaho's constitution and the common law only need to be examined. That was, I believe, 1600s law, way back in the day. They go back, don't they? She goes back. I believe she cited a law from the 900s on one of her motions. She goes way back if she needs to. Okay, C. Even if Idaho Code 191107 and Rule 6.5A conflict, the rule controls and the result is the same. Couldn't say it any better. So I remember looking up all this stuff on substantive law, and that is how it is resolved. The rule controls, and the result is the same. So they're saying you're wrong. The statute doesn't control, the rule controls. And we're scrolling again. More cases, more cases, more cases. And page 11 is my favorite part. You might recognize it here in just a second. D. Defendant asserts a theory the law does not allow and seeks a remedy this court cannot grant. I'm going to read that again. Defendant asserts a theory the law does not allow and seeks a remedy this court cannot grant. I mean, how can you throw shade any better than that? Legally speaking, defendant's motion should be denied as it rests entirely on an erroneous legal theory, but it has other problems as well. Okay, let's see. I just not mention. Okay, now this is interesting. The statute that sets out the grounds on which a defendant can seek to set aside an indictment does not even mention instructions to the grand jury. And the inclusion of specific grounds to challenge the indictment in the statute, quote, excludes the consideration of any other, unquote. Okay. Defendant claims the Idaho Supreme Court, this is my favorite part, has adopted the theory that a defendant can challenge the grand jury instructions, but he cites for this rule a passage in Gasper that he previously labeled dicta because it did not suit his argument. It seems to the state that dicta for the goose is dicta for the gander. Lawyers all over the place are applauding right now. That was good. I'm sure you've all heard the saying, what's good for the goose is good for the gander. And that's a good one. All right. And we're scrolling. I think that's pretty much, I think they made one more point down here. And this is one of them right here. We're almost done. The requirement that the state prove every element of a crime beyond a reasonable doubt is grounded in the constitutional guarantee of due process. Well, there you go, genius. That's what it means. Due process, a jury trial, not a grand jury where the defense is not even there for due process. That is a constitutional guarantee. Okay, let's see. They're calling things that Anne filed misleading here. Okay. And so basically, they're just saying that some of the things that she put in her last response were misleading and incorrect. And then conclusion, this court should deny defendant's motion to dismiss the indictment because the standard of proof that applies to grand juries in Idaho is probable cause. All right. And then all they did was attach a whole bunch of case files where things were discussed about probable cause and grand juries. They did a whole bunch of them. They did way more than they needed to, honestly. So I'm going to link this document if anybody wants to go scroll and look at all those. We don't need to for this purpose of this video. All right, so what I think is going to happen is I believe that the state will win on this matter. I don't believe the judge is going to dismiss the indictments on any grounds. The defense is doing a good job bringing up technicalities and all that. However, I don't think it's going to fly at all. I just don't. I don't think it's going to fly at all. There's no way that they would change the way they've been doing things for hundreds of years. They're just not going to do it. It's already, like they said at the very beginning, the whole modern of jurisprudence on this issue is against it. It's just the way they do it, and it's the rule. So I don't believe that the defendant will win their motion to dismiss the indictment. Don't think there's going to be a setting aside of that and doing a whole prelim and everything. And I don't like saying that because I kind of wish they would win. I wish we could have had a preliminary hearing. I would have preferred that. I don't like grand juries at all. I think they need to be done away with, in my opinion. Any matter that is going to result in an American getting put in handcuffs and behind bars, I think they need to do a preliminary hearing every time. But anyway, I think the defendant had a right to speak and be heard and defend whatever they could, guilty or not. So that is what I think about these documents. You let me know what you think, how you interpreted them. I know different people interpret them a little bit different, and that's fine. That's cool. That's what we're all here for. And just try to get it as correct as I possibly can. And if I have made any errors in this, feel free to let me know. You can comment or you can email me anytime about anything. Thank you very much for watching this. Again, the hearing is tomorrow morning, 10:30 a.m. Idaho time, which here in my time zone, Central, will be 12:30. I'll be watching for any possible live stream, which I doubt is going to happen. I believe it's going to be just recorded and released later. And the families of the victims and Brian's family are going to be allowed to watch via Zoom. So we'll see what happens tomorrow. It's going to be a big battle. If you haven't caught my live on this as well, on what to expect and what's at stake, please go back and watch that. I'm going to link it above right now. So you can right click on that link and choose open in new tab if you're on a computer or laptop. And then when you're done hitting the like button on this one, you can go watch that one and let me know what you think there. All right, guys, thank you so much. Have a great night, and I will talk to you again after the hearing.